Hey folks, welcome. My name is Jamal Lundy. I serve as the Intergovernmental Relations Manager for the Hennepin County Attorney's Office. Thank you so much for coming out. Obviously the purpose of the event is season for second chances. We'll be talking about prosecutor-initiated sentence adjustments and expungements. A couple of housekeeping things. The restrooms are over there, so if you do need to get up, please feel free to come over and check out the restrooms. Foods, plenty of it. There'll be a second round of orders, so don't be shy about grabbing them. We don't want to take any back. And just really want to thank you all for coming out. So first up, just want to offer a quick overview. You've probably seen on your handouts. We'll be starting with a welcome, then a poetry reading, introduction, and then a presentation from two of the senior attorneys in our office. But with no further ado, I'd like to introduce our first speaker, the founder and CEO of Allsquare, Emily Turner.
Hey everybody, thank you so much for coming out tonight. Thanks for coming out on this very chilly night into this cozy space. We love having people with us, especially on nights like tonight. As Jamal mentioned, my name is Emily Hunt Turner. I'm the CEO of Allsquare. And for those who don't know, just a little bit about us, we are a civil rights nonprofit here in the Twin Cities, and we invest in folks who've been impacted by the prison system, by mass incarceration. And we do that in a few ways. One, through our restaurant and food truck. I hope you all get to enjoy the product of that magic. We have a grilled cheese restaurant and food truck. We have folks who have come home from prison, who both work in and lead the restaurant. And we also have a recently opened law firm in St. Paul, where we are working with folks on civil legal issues and also running a prison sellout pipeline program through our legal revolution that is facilitating Juris Doctorate law degrees and also paralegal degrees for the folks who are still incarcerated. As someone who learned the law from folks who are on the inside, teaching themselves the law in ways I couldn't have imagined, super honored to be a part of that, and always really grateful to Mary, who's been supportive of our legal work from the jump. So, quickly just want to name for us, our name, Allsquare, I think lends itself really well to the evening in that hopefully it says something really important as it relates to what's happening and to what folks face when they come home, which is, once you have a criminal record, really of any variety, it's really hard to move forward in life. And so our name, Allsquare, our brand, if you will, we hope says something about, when folks have come home, when they've paid their tickets, when they've done their time, they're all square and they're free to move forward. And we're here to be a part of that side by side with folks. So the last thing I want to say is one of the core values here that I think we all feel pretty strongly about is personal accountability and systems accountability. And we are very intentional about putting those two together because often they're not. And when you decouple them, I think that at least I've been a witness to a lot of harm unintentionally surfacing. So, something for us that I think has been really important and something I've always really appreciated about Mary is making sure that when we talk about either, we talk about both. From my opinion as someone who was trained in the law and practiced law for many years, we're really comfortable talking about personal accountability, and I believe that's very important. But when we aren't taking into account the really deep issues that are inherent in the criminal legal system, when we aren't naming them, when we aren't speaking to them, when we aren't accounting for them, it can really prevent ultimately growth and healing. And something I've just really appreciated about Mary and how she moves is the way that she holds those two things together. So with that, I will shut my mouth and hand it off to someone more talented to do some magical poetry. And thank you all again for being here. We just love hosting events like these. So thank you very much.
Thank you, Emily. So also wanted to, have a community voice here, so we invited Essence Blakemore. You may have seen her at the MNJRC event last year. You may have seen her at PBS, but she's, a young spoken word artist that we'd love to have and invite to the stage. So thank you so much.
All right, thank you so much for the warm welcome. Again, my name is Essence Lakemore, and I'm gonna just hop right into the poem. And I'll step on this chord. The revolution will not be televised, but paid in full. The idea that spreadsheet numbers could tell you anything else scares me. What do you value in this life? Check your positionality. Our lives are dependent on the vagaries of fabulous and suits, skirts, ties, shoes, all stacked against me. Some people, you can tell, do the wrong thing when nobody's watching. Some people cop out using buttons and stickers. But you partake in feeling noble about showing the best gift given to humanity, love. Everyone knows love don't cost a thing. Maybe they don't know. The revolution will not be televised, but paid in full. When I was a child, I was told not to tell stories, not to lie. And if you take something from somebody, you give it back. I just told a child, when you hurt someone's feelings or their bodies, you apologize, but only if you mean it. I'm an adult circling conversations about expungement, sentencing, and reparations. The revolution is not going to be televised. It's going to be paid in full. Life cannot be replaced. Time can only move on. The innocent names deserve the light. Too many department acolytes looking for accolades because they gave healing a chance. Today, we stop clapping for kidnappers. Today, we seek the gift. Tomorrow, we receive the promise. The revolution will not be televised, but paid in full.
Thank you so much, Essence. Thank you for those words. And so next we'll have our Hennepin County Attorney, Mary Maiorty, come and speak some words, some introductory remarks to center us on what we're here to talk about. Thank you.
Thank you and welcome. I'm so happy to see all of you. Long before they became a law firm, they were the restaurant here. And I was a frequent patron of the grilled cheese sandwiches, which are up here. So I want to encourage you in the back, everybody come on up and help yourself anytime you, because we've got a bunch of food here. So I had remarks for this. And in the middle of the night, unfortunately, I had an epiphany and I was thinking, what do I really want to say? And how many of you are familiar with Emily Baxter's work, We Are All Criminals? Yeah. Everybody think? Yeah. You know, for a long time, you know, I would hear Emily talk about any single one of us could be in this particular, we're all criminals, right? And I remember for a while, I thought to myself, no, I would never be in that position. And it came to me over a period of time that that's true, but it's only because of genetics and privilege and the fact that traumas that have happened to me, I reacted in a way that was all about achievement and being a good person and doing all this stuff. How many of you are familiar with adverse childhood experiences? Yeah, I have a lot of those from my childhood, and many of you do too. And one thing I always think about is because of the way I reacted to those, and whether it's genetics, whether it's because my family was pretty privileged, I had opportunities that other people didn't have. And whether it was genetics, whatever it was, I was very resilient and able to do things that I wanted to do. And I think it's really important for all of us to think about the fact that not everyone has that. Many people don't. And so I was thinking about the ideas of redemption, second chances, and those don't resonate for me. We're always asking for second chances for ourselves, right? Second, third, fourth, fifth chances. What does redemption mean? I think this is all about how do we help people in the community thrive? And as you know, when somebody does have a conviction, It is a big barrier to housing, getting a job, all kinds of things. And so why wouldn't we help someone overcome that barrier so that they can be successful? Because don't we want them to have a good job? Don't we want them to go to school? Don't we want them to have permanent housing where they can raise their family? We all want that, and we should want that. And we should want that for every single one of our community members. And we, as a system, have to have some humility about where we are and extend that humility and think about, how can we lift up people who may not have had the advantages, the privileges, the genetics, whatever it is, that allowed us to go a different route from trauma, when not everybody has that and it's not their fault. So I'm not going to talk about redemption. I'm not going to talk about second chances. I'm going to say we have an obligation, especially as a system which has inflicted mass incarceration, the war on drugs, inflicted a lot of barriers on our community members that has made it extremely difficult for them to re-enter the community, for them to be in community, and for them to succeed and thrive. So for me, that's what this is all about. We are extremely fortunate. I'm not sure if Senator Zainab is still here. She was making the rounds. But our legislature gave us a really important tool this year. And Claire and Jill are going to talk about that. Prosecutor-initiated sentencing adjustment. We also have had a tool, expungement, that's kind of changed over the years, but our office has been fairly stringent in that. And in fact, I was talking to a guy not too long ago who many years ago was actually prosecuted by our office as a youth, an emerging adult. And he was talking about the fact that over the period of years, he was a young man, and he acknowledged what he had done. And he said, I fought very hard to make different choices in my life, and I was able to do that. And so years later, he had asked for an expungement, and our office opposed it. And when he appeared in court, the judge lectured him and refused to grant it. And I asked him, so are you thinking about applying for an expungement again? And he said something that really resonates with me right now. He said, I am tired of asking for forgiveness. I have worked really hard to move my life in a different direction. I have forgiven myself. And it's so powerful because how long are we going to punish people for mistakes that lots of other people make or that they make and they're really trying to be successful? So thank you so much. Come on in.
Where should we go?
You should. The first thing you should do is get some grilled cheese sandwiches and chocolate chip cookies, and Jamel has some chairs here. So welcome. Thank you for coming. Thank you. So thank all of you. And this is the first of other community forums like this. We want your feedback about what's working well, what you think we can improve on. We want to engage with our community. The only way we are going to be able to move forward in a good way is for us to work together. So thank you so much. I'm so excited about this, and I'll hand it back to Jamel.
Thank you. And so next up we have Clara Deagle and Jill Barreto, who will be speaking about our second local review authority.
Just go like this. Hi everyone, thank you so much for coming out tonight. It's really amazing to see such community interest in these really important tools that we're going to be talking about today. So my name is Claire Deagle. I'm the Director of the Division of Professional Standards at the Hennepin County Attorney's Office. It's a division that Mary created. I've been with the office since the end of May. But she created to really focus on a lot of what we're going to be talking about today. What are the tools that we can be using to help our community and to try to remedy the effects of mass incarceration? So I I'd like to just introduce some of the folks that are working on the team with the Division of Professional Standards. Like I said, my name's Claire. I was a public defender here in Washington State. I was also most recently at the ACLU of Minnesota, where I did a lot of work with incarcerated people, particularly during COVID. My dear friend and colleague Jill Barretto has been a public defender for 7 years before joining our office. We also have with us Piper Wold, who has decades of criminal defense experience. Piper is an attorney at the Resentencing Project at St. Thomas Law School, and St. Thomas is partnering with us on the prosecutor-initiated sentence adjustment. So I'm going to talk more about that, but wanted to recognize both of those folks. Cole Beaton is also here somewhere besides putting up this event. He's also on our team, and it really resonated with me when Essence, you talked about spreadsheets, because with a lot of our work, we've been poring over spreadsheets of every single person incarcerated in Minnesota with a Hennepin County conviction. And it is a really important reminder that people are not just a number. And we're going to talk about how we're going to do a holistic review and all of that, but really appreciate you saying that, because it's something that's been on the forefront of our minds a lot. Also at St. Thomas, we have Monique Salvetta and Julie Jonas, so we're super fortunate to be working with them. So we're going to be covering clemency, aiding and abetting felony murder. There's retroactive resentencing that the law now allows, and then we're going to be talking about the sentence adjustment. So I'm going to hand it over to Jill.
So I'm first going to talk about clemency, and there are two main points when we're talking about clemency. The first one is pardon, and the other one is commutation. So when a person applies for clemency, they're applying for either a pardon or a commutation. And the difference is slight, but it is there. For pardon, that's the definition that the statute gives, but also the Board of Pardons, an act of forgiveness that exempts the convicted person from the punishment imposed by the law. And that is generally somebody who is trying to put aside their conviction, and this way they don't have to report that they asked for a pardon. When they're looking for a commutation, it is the substitution of a lesser or different type of punishment that was originally imposed. So if a person is in prison and they are requesting a commutation, they are asking for that either a release. They could be asking for a change in their sentence. For if somebody was serving a consecutive, to make it concurrent, so instead of after, it'll be running together. They could also be asking for to be placed on parole instead of being incarcerated. All of that would fall under commutation instead of a pardon. So it's a small change, but just there. Folks can look up information from the Board of Pardons, and the website is up there for that. And then the Pardon Board consists of 3 people: the Governor, the Chief Justice, and the Attorney General. And I'll note that for right now, this is only relevant for the next 6 months. And then after that, there will be a change where a Pardon Board will make a recommendation to the Governor and these folks for it. There'll be a totally different system. So we'll be updating that as we come to learn what that system looks like. But specifically, you need the Governor and somebody else, either the Attorney General or the Chief Justice, to agree to support either the pardon or commutation for it to go through. So, in order for that to happen, people will apply. They will go before the Pardon Board, and they will have the opportunity to have their case heard. And from then, it will be up to the Governor, the Chief Justice, and the Attorney General to make that decision. Our office plays a small part in that, in which we get the clemency requests, the application requests. We review the applications, we go through the case file at the time, we reach out to victims or victims' family if we can, to see what their input would be, and then we make a recommendation to the Pardon Board about what our office thinks is the appropriate end result of the case.
And so unlike clemency, which happens outside of the judicial system, outside of the court system, now I'm going to be talking about things that happen in court. So the first is aiding and abetting felony murder. So for those folks who don't know, felony murder is when a death occurs during the course of a felony crime when there was never any intention to cause the death. So it's how someone can be charged and convicted of murder without actually having an intent to commit a murder. In addition to felony murder, there's another statute in Minnesota that allows someone to be charged and convicted with helping or aiding and abetting the person who committed the felony murder to also be charged with the murder via felony murder. So we have there's over 160 people who have been convicted of aiding and abetting felony murder under that old statutory scheme. The legislature changed the law in May and has now really narrowed the number of people who can be charged with aiding and abetting felony murder. It's a really big deal, and Minnesota is actually, I think, like been a leader in the country on this. California started, but we really took it all the way. So now someone can only be charged and convicted of aiding and abetting felony murder if they had an intent to kill or if they were a major participant in the underlying felony who acted with extreme indifference. And major participant, what does that mean? The statute defines it pretty narrowly. So for everyone going forward, they'll have the advantage of this change in the law, but the legislature, and this is one reason why this law is such a big deal and is really unique, the legislature is actually allowing for retroactive relief. So that means if someone has been convicted of aiding, abetting felony murder in the past, they may be eligible to apply for resentencing under the new law. So not everyone who's been convicted of aiding and abetting felony murder is going to qualify because the judges are going to be looking at whether or not they would fit or would not fit into one of these kind of two categories. So the courts have the law set up a two-step process for people who have been convicted of aiding and abetting felony murder to seek relief for resentencing. So the first is an application. This is available on the district court's website in the forms section. You can just Google Minnesota District Court forms felony murder. That's a lot, but easier to Google that than just put up a website. So the individual would apply, and then it just goes to the court. Sometimes we see them, sometimes we don't, but we do not get to respond. As the state, we don't get to respond. The judge then makes a decision, grant, deny, on the basis of the application. The judge grants the application, then the individual gets to file a petition. The petition is going to be much longer, much more in-depth, and that's where the state, we review it, and we have an opportunity to respond. And their discretion is pretty limited because of the statute. So what we're really looking for there is, does this match the new statute or does it not? So we haven't had too many of these yet in Hennepin County. We've had quite a few applications, but so far only 2 petitions that have been filed. Oh yeah, okay, now the big new change, prosecutor-initiated sentence adjustment. So the statute is up here, 609.133. But this is a really big deal. This is something that a lot of other states have started to do. And so it's really great that Minnesota got on board so quickly and is allowing this relief for people. So under PISA is what we're calling it, a prosecutor can file a petition to try to convince a judge that it's more likely than not that there are substantial and compelling reasons, okay, that's what we're going for, substantial and compelling reasons to adjust an individual's sentence. And that adjustment can be in any way, except it can't be up. So it can't be worse. It can only be, down, decreased in some way. There's really broad discretion here. The statute does not limit crime of conviction, and it does not limit to length of sentence. So any crime of conviction, any length of sentence, we think any type of sentence, maybe TBD on that, any type of sentence can be eligible for this. So PISA is really a data-driven solution to many of the problems resulting from mass incarceration that Mary touched on. And so we're really excited about this opportunity to be able to relieve people of excessive sentences who can be safely returned to the community. This is something that we petition the court, and then ultimately it is a judicial decision. As part of our obligation as the state, we do victim outreach, we consider victim impact, and that is part of the petition. So as I said, we haven't had any court hearing or court orders on this yet, but this is something that's coming, and Jill's going to talk a little bit more about the details.
So a little bit about what we are looking at. We are looking, as Claire said earlier, about data from the DOC. We're looking at trends to try to understand what's happening. More than that, it's what's happening to people while they're in there. What age were they admitted? How much time have they been serving? What access have they had to programming? What access have they had to work? all of those things across the various prison systems and trying to figure out what is going on where and how that might affect what we're looking at when we just get data in a spreadsheet, because we know that the spreadsheets don't tell us everything. So what we're looking for are, right now, as we're analyzing this data, we're looking for people who have been incarcerated for an excessive amount of time. And that means that from the DOC, nearly 69% of people serving Hennepin County convictions are there for crimes committed against people. And those are the people who generally get the longest sentences. Where the people who are in for drugs or in for property crimes don't get nearly as long as the sentences for crimes again, that were committed against people, which is what we're looking at generally. We're also looking at the time of offense and how old the person was at that time that they committed the offense, how old when they were committed to the DOC, and how old they are now, and what's happened between that time. We're looking at rehabilitation. What programs have they done? What has been available to them? But also, we're looking at discipline. What has happened in the DOC while they were there? One of the things that we are considering while we're looking at this is also, for crimes, what has changed. There are sentences that have become longer, and we're looking to see what, or are shorter, depending on the crime committed, and we're looking to see what trends are there. Is somebody committed for a drug case in the 90s, they're getting a different sentence now. So we're trying to look at across the variety of different crimes to see what has changed in that same way and see if we can identify those trends in the DOC. So there are four main components of PISA, or what we're calling the R's. So we review, we look at rehabilitation, we look for reentry, and then we have to request the victim input. So review, we're doing case review, and that's where St. Thomas has come in. We have two attorneys that we're working with who are helping us look through the case file. So what happened at the time that the person committed the offense? What did the case file look like? What was going on there? Then we look towards rehabilitation. What is going on now? What steps has that person taken since being committed? What have they done? And then it's reentry. What will happen after they leave the DOC custody? Do they have community supports? Do they have family support? Do they need community support or family support? Or do they need mental health help? Do they need medical help? Those will be all, employment. Do they need housing? Those are all things that will be used for somebody's success, all tools for somebody's success. And we want to see what the person has, but also where they could use help and what could be then offered to them. One of the things that we note is that we're not doing this alone. When we decide that somebody is going to be a serious applicant, they will be appointed counsel, and then that counsel will work on them in making sure that we get that information to support that application.
And I'll also say that we've been in discussions with the DOC for months about how to best streamline the process of getting information from them quickly, and the DOC has been extremely helpful and willing to work with us on figuring out a quick way to get information so we can try to process these quickly as possible. So we are doing an internal review, but we are going to start taking applications for this. So what that means is that we're going to put an application on our website. It's about 10 pages. We're going to put it on the first week of February, and that's the information that we're going to use again to try to do a holistic review of the applicant. So for folks interested in this, or if you have family and friends who are incarcerated who are interested in this, we're asking, please only send us the application. Please don't send us any original documentation or extra documentation. And also, please apply yourself or your representative. Family, friends, so well-intentioned, and we know you want to do everything to help, but we really need some information directly from the applicant themselves. I also want to note that we have just over 2,000 people in Minnesota serving time on Hennepin County convictions, which is about 25% of the prison population. Not surprising, but startling and troubling. And so we anticipate a lot of applications. With that in mind, we'd ask two things. There'll be time for questions in 1 minute, if you don't mind. So with that in mind, we're asking folks to I know it's hard to say be patient, but just know that if we get your application, it's in the pipeline. We will communicate with you at certain times when we can. But also really make sure rehabilitation, re-entry, if you maybe need or your loved one maybe needs a little more time to build up that part of the petition, that's okay. This doesn't seem to be going away. Aiding and abetting felony murder, there's about a 2-year timeline for which people have to request resentencing. PISA, there's no time limit in the application. So just wanted to put that in folks' radar. So key takeaways for PISA. The law is very broad and it gives us wide discretion, but it doesn't give us ultimate authority to adjust someone's sentences. We're gonna put up the PISA application online on our website the first week of February. And our goal is to do a holistic review of the applications. The 4 components to keep in mind, we're gonna review the past case. We're gonna look at what rehabilitative efforts the individual has been able to accomplish. We also know that that's not always on the incarcerated person. We know that programming shut down during COVID, that some places in the state, they're programming that is not available to people. So we're also, mindful of that, but please just keep that in mind. Also reentry planning. Someone doesn't have to have a perfect reentry plan, but we do also want to try to help connect people with resources. And so we do want that information. Then we'll be requesting victim input. We'll be providing updates when we can, and we'll have more information on that on our website. And then if we think someone's an eligible candidate, we'll have a defense attorney appointed. So having a defense attorney help with the application will not make the process go faster. So you do not need to hire a defense attorney to help you apply to our office. This is so important, I really want to stress this. You're not going to skip the line. So, we're trying to do the right thing. We're going to do a holistic review. And if we get far enough where you need counsel, we're going to try to get it for you. Okay, I think now we have time for questions then.
Smart.
Oh, is there another slide? Mr. Mouse, so good.
Yeah,
Yes.
so, if your family member is incarcerated or got a life sentence, that application got sent into the DOC?
So we're gonna talk to the DOC about how best to distribute these because they were obligated by law to have the applications for aiding and abetting felony murder available. So we are gonna talk to them about having them available in the facilities. But yes, that is a big question mark.
It's going up February, but it's not gonna be in the DOCs.
Probably not right away. But again, probably not within that time frame, because we're just trying to get these up and out. And we know community can help with that too, getting the word out, and that's why a lot of you are here. So we're hoping that, you can print it out and send it to your friends or family, and then they can send it to us.
Claire, can you repeat the question?
Yes, the question was,
No, I mean in general.
oh, yes. Do you want me to repeat that one?
Yeah.
Okay, and please correct me if I was wrong, but the gist was, how would an incarcerated person get access to the application if it's gonna be up online? Yes,
Yes, the PISA now, I'm somewhat familiar with the whole process of trying to get back and doing appeals and everything. So with the PISA, what's the difference between y'all using that and using NAFLA to bar somebody, honestly?
that's a great question. So the question was, as I understand it, what's the difference between PISA and going through an appeal?
2702.
Yes, or
27 Division 3.
Maybe a post-conviction, maybe a post-conviction. So this standard is different, the legal standard is different. So the legal standard under PISA is focused on whether there are substantial and compelling reasons to adjust the individual's sentence. So when anyone is going to court and arguing that you were wrongfully convicted, or you had ineffective assistance of counsel, or the prosecutors committed misconduct, whatever the reason, the judge is looking at that legal issue and trying to make a determination. Here, the legal issue is whether there are substantial and compelling reasons to adjust the sentence. So it's not about the underlying crime. The statute does say that we need to provide information about it, and the judges will be considering it. But the question is not about a defect in the underlying case.
Right, well, that's what 2703 subdivision 9 is, it's straight sentence, and it doesn't deal with the case in the same similar language.
Oh, I see.
And that's all I'm asking, what prevents
Oh.
y'all or the judge from stopping or denying it based on the fact that it's, it didn't come within 2 years?
Sure.
Is what I'm saying. Do y'all have anything that states that NAFTA can be used in this situation?
I'm sorry, I hadn't heard the resentencing part of that. Sorry about that. Yep, so there's nothing in this statute that has a time bar. So that's one difference, but ultimately it is up to the judge. So it's prosecutor led, which means that the individual whose sentence is being reviewed isn't fighting the state, typically not the case. So it is a very unique situation where the state and the defense are going in. We think for the most part we'll be going in agreement. There may be some times when there are slight disagreements about, I don't actually think that would happen, but it could happen. So here, there's like an agreement by the parties. So for the individual, this would be a likely more successful way to go. There may be circumstances wouldn't, but this would probably be a more successful way to go because you're not fighting the state.
We'll be all day on that one.
Yeah. No, I appreciate the question. I'm sorry. Yeah.
So, are you guys looking to push this past the county, and maybe go state and like to different states? Kind of what's the forward plan beyond just the county?
Yeah, so the question is, are we looking to push this past the county, go to different states? That brings up a really important point that I wanted to address. So this is a statewide law. So any county attorney's office in the state can file these petitions. I do want to be clear that what we have talked about is Hennepin County's position, Hennepin County's plan. Other counties may be doing this differently. So depending on where the crime of conviction occurred, you'll want to note that because there are going to be differences.
And so, real quick, so Minnesota's not Minnesota or Hennepin County is not the only city or state that's kind of moving on this.
Correct.
So my question is, with PISA, people that are convicted, even if they submit the application, they are approved, they say, hey, yeah, you should not be serving this much time. They still have to carry that record of what they were convicted of, which still, in turn, when they get back in society, they still have to apply for jobs and say, I was convicted of X, Y, and Z, even if some of them are innocent. So this don't deal with the fact that some of them didn't commit a crime.
Correct.
Or this just gets them out early.
Yes.
Correct.
That's what expungement is.
I was just going to say, but you just set us up for our next presentation on expungement. I don't know if they're, yeah, and Jim.
Thank you so much. This is super helpful. I'm supporting a loved one who has done a lot of time and has done a lot of programs over the course of his time, but has had a really hard time getting records of the different programs he's participated in, especially because he did time in a few different states. And I'm curious, obviously I haven't seen the application, but just if there are ways to sort of substantiate the work folks have done, even though DOC doesn't always keep the best records of what people have been a part of.
And I can talk, so this goes to, if somebody has done programming, if somebody has done the programming, but the DOC might not have record of it, is there a way? So on the application, there will be a place that somebody can fill out what programming they've done. And it will be a way for them to advocate for themselves in that. We are getting DOC records. We know that records are not always the complete picture, but just taking a look at that. So that's why we ask everybody to be as clear and complete as possible in the application, so that this way we have that record of it.
Will the PISA filing let it back to the sentencing judge?
Great question. Will the PISA file go back to the sentencing judge? We don't know exactly. We anticipate that if the sentencing judge is still on the bench, it will probably go back to the sentencing judge. We have time for one more question, but then there are more time for questions at the end. Yes, and so the question is, what's the turnaround time once applications submitted? And I'm going to give you an unsatisfactory answer because we don't know the number of applications we're going to receive. So one of the reasons I wanted you all to know that we have a team of people working on this is to show you that we are committed. Mary has put a lot of resources into this, so we are committed to do this as quickly as possible. At the same time, I mentioned 5 people, so we've been trying to set up systems internally and with the DOC to make sure we can get the information quickly. If we get 2,000 applications on February 8th, it's gonna take us some time to get through them. If we get 2, it would take a matter of months probably. So I'm sorry we don't have more of an idea, but we will be providing folks updates. So, when we, they'll know when we get the application, when we moved it to the next phase, and all of that. So, I think we have to move on to expungements now. Do you want to talk about completion?
Well, thank you so much. I just want to mention that we'll have time for general questions at the end. So please just hold your questions. We just want to make sure we make it through the full program. And also, please feel free to come up and grab some food. And if you're standing in the back, we do have about two-ish chairs over there, I think. We have at least 1 chair over there now. So feel free to come up. If you're looking for a seat, please come up. So without further ado, however, I'd love to move on to the next part of our program, which is the adult criminal expungements. Do not be shy about the food. We don't want to take any home. So if we can't put our hands together for our next presenter, Nadia.
Good evening, everyone. My name is Nadia El-Neki. I am an attorney with the Hennepin County Attorney's Office who handles all things expungement. So I'm here this evening to give you a sort of high-level overview of expungements in general, and then a little bit of a deep dive on our prosecutor-led initiatives and the new legislation that has just been passed that will make it easier to have records sealed. No, I'm good. I just don't think there's so many microphones that I don't think we're using any of them. Okay. So, just in general, overview about expungements. To be clear, expungements is about the sealing of criminal records. There is nothing in any expungement statute that allows for the destruction of those records, and in fact, records can be opened for reasons that are listed in the statute itself or by court order. Expungements is governed by Minnesota Statute 609A.02 for anyone interested in a little light reading. And I want to tell you that when a judge is considering an expungement petition, they're thinking about 2 things. And this is a theme throughout, and it will help you sort of help expungements make more sense, because I will admit that the statute is not super clear. Expungements is about what you did at the time of the offense, your behavior, the level of involvement in the offense itself, and then what have you done since that time to indicate to us that you're not a problem anymore. We don't have to worry about you. You're going to hear me talk about 2 categories of records that I'm going to reference throughout this presentation.
Speak up a little bit. I'm sorry.
Wow, I have never been called too quiet in my whole life. Okay. I saw it happening in real time. Okay, we'll try this way. So there are, like I said, 2 categories of records that you're going to hear me reference. Judicial branch records, these are the ones that show up in a public case search, the Minnesota Public Court Access, and then executive branch records. These are records that are maintained by law enforcement, by community corrections, by prosecutorial authorities, basically everybody else. Why do people seek expungement? There are reasons that are pretty self-explanatory. Housing. The dearth of housing means that landlords can be really picky. Employment, even just an arrest record on your record will disqualify you for employment these days. Licensing for DHS. Do you want to be a PCA? Do you want to foster your grandbabies? DHS will disqualify anyone with an arrest record from working with children or vulnerable adults for 15 years. Coaching opportunities with your kids. Do you want to coach your kids' team? Do you want to volunteer in their class? Do you want to be a troop leader? You can't do any of that with a criminal record. And honestly, there are quite a number of people who just want to have their records cleared, just for bucket list. No other reason than I want it to be gone. This is the general expungement process. So if you were to petition the court on your own, this is sort of what it looks like. We start with the preparation of and completing the petition. It's 13 pages, mostly identifying information, some sections that ask about what you've done since the offense that you feel qualifies you for an expungement. A copy of that petition needs to be served or given to every single agency that was involved in your case. And this means not just the prosecuting office, but community corrections. Were you on probation? They need it too. After that's done, and notice has been served, you'll get a hearing date that is at least 63 days out. That 2-month span exists to afford all of those agencies an opportunity to weigh in on your petition. Agree, object, take no position, what have you. The hearing itself is a pretty short proceeding. That's an opportunity for the subject of the record to make their case to the judge, for the judge to ask any clarifying questions, and allow you basically an opportunity to explain what happened and why you think that you deserve, or why the court should believe you that it's not going to happen again. All petitions are taken under advisement, meaning that no decision is made in court that day. In fact, decisions usually take about 5 to 8 weeks to come out, and if an expungement order has been granted, that order itself is stayed for a period of 60 days on the back end as well. That is to allow all of those agencies an additional opportunity to appeal the court's decision. That has literally never happened, but it exists and we can't do anything about it. And after that, records are sealed. Okay, types of expungement. With the creation of this new Clean Slate Act that you guys may have heard of, we now have 3 types of expungement. First is statutory expungement. These are for felonies that are literally listed in Minnesota Statute 609A.02. There are 2 separate mechanisms that you can go about getting a statutory expungement. The traditional petition, which is that process that we just lived through, and what's called prosecutor-led expungement, which we're going to talk about in greater detail in just a little bit. If an expungement is granted under the court's statutory authority, that means that both judicial and executive branch records can be sealed, which looks like this. So this is best case scenario for having your record sealed. Admittedly, there are limitations, and it's called the internet. The internet is forever, we can't touch those, there's nothing to be done about what exists on private websites, but every other agency's records can be sealed. An inherent authority expungement. This is for offenses that either aren't included on that statute list, or if the waiting period hasn't been met yet. Statutory authority expungement comes literally from the statute, right? The power is given to the courts by the legislature. The power for inherent authority expungement comes from the court's ability to govern their own records, basically. The inherent power of the court to control its own internal records, which essentially means that the court can go around the statutory requirements, but if they do so, they can only touch their own records and no one else's. So it looks like this, which is not great. However, the MNCIS, or the public case record search, is what most people come up against when they're doing background checks for employment or housing. So it is still helpful. I don't want to discourage anybody from trying to seek an inherent authority expungement.
What does that mean?
How do you mean? Say more.
What do you mean? You said the courts can govern their own court records, so are you saying like a judge can go and say, oh, I didn't do that, I can wipe it off, I'm confused. So we'll go back a step. So the statute itself gives the courts the power to seal records, but if the record that we're talking about isn't eligible under the statute, the courts have a separate power that's called their inherent authority to control their own records. So it's just a different kind of permission, a way the courts can go about sealing judicial branch records. So for people or for
For the person. So the individual's records. I feel like the legislature did this to punish me. It's super not clear. The statute is really convoluted, and I'm trying to distill the information for you. But these are really good questions. So please, if it's not clear, I work in this every day, and I forget what people don't know. So please stop me. Okay, and then this is the latest one. This is the exciting stuff. Automatic expungement, which is actually automatic. For the first time ever, it means what it says. This is a new legislature has recently passed this that allows essentially for the Bureau of Criminal Apprehension, the BCA, to, in certain categories of cases, automatically expunge those records once certain criteria have been met. There are these categories of cases. So in instances of dismissals or exonerations, the BCA will seal records immediately upon dismissal of charges filed, In instances of, okay, I'll take a step back. That statute that I cite there, 152.18, for those who don't know, it is for first-time, low-level drug offenses. And it essentially affords those individuals an opportunity to avoid a criminal conviction on their record, right? It gives you, we basically what we call the stay of adjudication. We defer prosecution for like a year. We give you some rules to follow, and if you do well, then nothing ends up on your record. In terms of automatic expungement, there are certain drug crimes that if you are sentenced under Section 152.18 and you successfully complete that program, they will be automatically sealed. And finally, in the category of dismissals or exonerations, they're what we call resolved in favor of cases. And a resolved in favor of case essentially means an instance where you didn't, instances where there was no guilty plea that was entered and there were no facts that were admitted to. So in those top instances, your records will be sealed immediately. In instances involving non-felony diversion or stays of adjudication not under Chapter 152.18, the subject of the record has to go 1 year without charges after they get off paper, or for 1 year immediately preceding the BCA review. Okay. This statute, if you notice up top, it says effective January 1 of 2025. It will apply obviously to all cases going forward, but it will also apply retroactively to all cases that exist in the BCA system. So that's what that review means. So they are required to regularly review cases going back in time as well and proceed under this new expungement law. With regard to convictions, it has to be a qualifying offense. You need no new convictions during the applicable waiting period, and you cannot be pending charges at the time. I don't know what I meant by or be, please ignore that. So when I say qualifying offense, the statute has it listed out. It's framed as like all misdemeanors except all gross misdemeanors except all eligible felonies, like the ones on the list, except. And the exceptions are what you would think. It's the DWIs, it's assaults, it's domestic related offenses. So those are the categories of cases that will not be automatically sealed, but everything else in theory will. Okay, you've heard me reference now a waiting period. And this is essentially how long the legislature has decided it takes to prove rehabilitation. The way that it's worded in the statute, please bear with me, I did not write it. It says, since discharge of the sentence for the crime. Now, if you're a regular person looking at that, it means to you that when you're done with the crime, when you're discharged, you have to wait this amount of time and then you are eligible to have that record sealed. That's not what it means, somehow. Because if that were true, you could never seal the record of any conviction that immediately preceded another one, which is the vast majority of the stuff we see. You have individuals who are suffering from addiction, and so they have short periods of unlawful behavior, but it's a lot, and it's in quick succession. So if we take the statute at its word, you could only ever seal records of that last thing that you did. But that's not what our goal is. So case law interprets this to mean that it's not the years that immediately follow you being done with that offense, but it's the years immediately leading up to the filing of the petition. So I call it a look-back period. It's how I reference it instead. Helps keep it a little more clear in my head. So starting today and looking back in time, have you gone the requisite number of years without anything on your record? And if yes, you are eligible to petition the courts to have your record sealed. So these are the timing requirements that I referenced. Whether we're following under the clean slate portion, so the automatic expungement bit, or whether you're petitioning for expungement in the normal course of business, the timing requirements are generally the same. There's only one difference. You can notice at the bottom in red, the Clean Slate Act says that if you go 5 years from discharge with no convictions on a felony offense, your records will be automatically sealed. If you petition on your own, however, you only have to wait 4 years. Make it make sense. I don't know. It might be a typo, honestly. Because it really doesn't make any sense. And believe it or not, it's actually broken down a little bit more than this, but the minutia is no one needs that in their life.
You got a question? What if you're on parole?
Right, so that's on paper. But hold on to that question and I'll come back when I'm done. Thank you. Prosecutor-led expungements. This is the mechanism that we use to allow us to seal records based on prosecutor agreement without the subject of the record having to file a petition. It is only available for statutorily eligible offenses, but it does greatly expedite the process. So it means that there is no petition, which means that there is no filing fee. If you're petitioning in Hennepin County, there is no notice period on the front end, so that 60 days is gone. Again, if you're petitioning in Hennepin County, there is no requirement for a hearing. We intentionally went to district court and asked for that to try and make this as efficient of a process as possible. The 60-day appeal period remains because there's nothing we can do about that, but it does take what you could reasonably expect to be an 8-month process and bring it down to about 3, which is better, right? Okay. Now our own specific prosecutor-led expungement initiative is called Help Seal My Record. It's not just ours, it's ours and 4 other counties, and then the Attorney General is handling, I'm getting ahead of myself, take a step back. So summer of 2019, Ramsey County and Washington County wanted to do a pilot program to see what it would look like if they had created an online application program for expungements. And the point is, or I guess the goal being to remove the biggest barriers that stop eligible members of our community from petitioning to have their records sealed and being able to move forward with their lives in an easier manner. Those biggest hurdles, as you might imagine, the filing fee, it's like $400, and also the ability to understand the statute, because it's not clear. It's not clear to lawyers, let alone non-lawyers. How it works. If you go to helpsealmyrecord.org, it looks like this. So we started first with just Washington and Ramsey. We joined in October of 2020, and since that time, Blue Earth and Winona have joined the efforts as well. Each one of these offices is only allowed to touch records that were prosecuted by their office. So we only have jurisdiction to seal records that were prosecuted by the Hennepin County Attorney's Office. The same with the remainder of these counties. All other counties and cities, the Attorney General's Office has generously agreed to sign on and handle all felony offenses, adult felonies for the remaining 82 counties, and then all municipalities. So it's all misdemeanors, all gross misdemeanors. I put that out there to say that if you're applying through the all other counties, it's a long list, as you might imagine. So just to manage expectations, that's going to be a bit of a wait. Got ahead of myself. Do it every time. Okay, so as I mentioned before, our process is really streamlined and intentionally so. So we had conversations with our criminal justice partners before we started the program, essentially letting them know what our goal was, letting them know they wouldn't be receiving notice on the front end, making sure they felt comfortable with what our criteria was. So our criteria for applications that we receive in our office are the statute and a little bit extra. So is it eligible under the statute? Have you met the waiting period requirements? And then our office has decided that in certain categories of cases, we're not going to proceed no matter what the outcome was. That's child abuse, sex assault, instances of domestic violence, homicide. We're not saying that you can't have those records sealed. We're simply saying that we're not going to do the work for you in those categories of cases.
Isn't that kind of like discriminating
Say more.
though? Like, you're choosing who deserves a chance of life. Based on
Less us choosing who deserves a chance and more us thinking about this. I think it's important to keep in mind, I don't know how do I want to do this? So these are categories of cases, well, we've thought about it, right? And these are not arbitrarily chosen. These are categories of cases that resolve in ways, so for domestics, for example, domestic violence offenses oftentimes get dismissed not because of factual innocence, but because the victim is not willing to participate in prosecution, right? Or instances of sex assault or child abuse, where you have a particularly vulnerable victim. So in those specific instances, because of the nature of those offenses, we're not going to petition on your behalf. It's not saying that you can't have your record sealed. It's simply saying that in these 3 or 4 instances, we're not going to petition for you. And that was a decision that we made as an office after careful consideration of what went into those types of offenses, how they normally were resolved. Victims' input is important as well, and so they had an opportunity to weigh in. And so that's how we came up with that criteria. Thank you for that.
So no matter how much time has gone by, say if it's 20, because I dealt with a situation where a guy was, I think the girl wasn't honest about her age, and then he got time for statutory rape. He was younger, so this happened when he was a teenager. He was 18, I think the girl was 16, but she told him she was 18. And then, so 20 years later, he wants to get this stuff, because he was a kid, he was 18 years old.
Mm-hmm.
So 20 years later, he wants to get this stuff expunged off his record. And so with that, so no matter how much time goes by, you guys wouldn't help with a situation like that.
I actually don't want to give it a bright line rule. Because each one of these cases is so specific and the facts matter, I need you guys to know that I look at all of them. My eyes look at all of them. So I look at all of the facts, I look at all of the information that's available to us, we make an educated decision going forward. So there is no, I say that we won't consider these category of cases as sort of a general rule. But I want you to know and feel comfortable that someone does have eyes on all of these things, and there are exceptions to every single one of these rules.
So would you want them to apply to, or what?
It doesn't hurt to apply.
So are you guys taking those
Can we
applications?
finish the presentation first? There will be time for questions. I want to make sure we get through them.
I'm almost done, I promise, and then we'll answer questions. Okay, so how it works is if you were to go to this website and you click on Hennepin County, you fill out the application on the right-hand side. We ask for basically identifying information, recognizing that a lot of people, especially with dated convictions, don't have accurate case information. That doesn't matter as much. So if you apply through our website, we look at your criminal record in its entirety. We'll pull out every single case that was prosecuted by our office. We'll analyze every single one of those cases for eligibility. If you meet the statutory requirements, then we'll petition on your behalf. And you literally have to don't do anything else than that. If you don't meet the eligibility requirements, you'll get a detailed response explaining exactly why and what your next steps can be, and providing you with a list of resources if you want additional help. And the one thing that I wanted to add, in the process, so this program has been up and running since October of 2020. As we've been going through it, we started to notice there was a large number of applicants who didn't have eligible convictions, but they were super old. So really dated convictions for offenses that aren't eligible under the statute. Meaning that the court won't allow me to petition on your behalf, but it becomes abundantly obvious that this individual has done everything we've asked of them and has clearly demonstrated rehabilitation. So further discussions with district court, we came to trying to help essentially as much as we can. And so in those instances where someone has a conviction that predates 2000 and they've gone 15 or more years with a clean history, we file what we call a letter of agreement, essentially indicating to the court that this person has demonstrated rehabilitation, and if they want to petition on their own, we will agree to the sealing of judicial branch records without requiring a hearing, just to try and make it as easy as possible. For, especially in instances, you might have noticed this trend toward more regular criminal record checks that wasn't what employers were doing before. And so, have someone who is of an advanced age, whose criminal record comes up, they get fired, and now they're out of a job and no one will hire them, and right, that sucks. So we're trying to do what we can to mitigate problems as we find them. And a few fun facts. Like I said earlier, it's hard to find bright line rules in the expungement world, but if there is one takeaway, an easy way to remember is that it's only felony convictions that are limited by offense type. I don't mean felony charges, so if you were charged with a felony but you pled to something lesser, you were charged with a felony that was sentenced as a gross misdemeanor or a misdemeanor, there are no offense-based restrictions in that regard. It's only felony convictions where the offense type matters. if you had an offense that took away your gun rights and you got that record sealed, that doesn't give you your gun rights back. That's a whole separate thing. Restoration of civil rights, you still have to do a whole other process for that. And then finally, if it was an offense that required registration, it doesn't matter under what authority, there's no court that can seal those records. Okay. Now I'm parched. Questions?
Oh, and really quickly, just want to let folks know that if you sign up for our newsletter, we will be announcing we're having an expungement clinic coming up probably late February. So just hammering out the details, the location, and the time. So, for instance, a lot of these questions or individual cases will actually have Nadia and others actually there to work through your expungements on site, and we hope that will expedite the process even further.
Before we get started on questions, I do want to put the disclaimer out there that I can't give case-specific legal advice. So if you have like very specific cases and you're like, what should we do here? I'm sorry, I cannot help you with that. But more general questions, happy to. Amy, had your hand up.
Go over again how people can, what's the first place that they need to turn to? You have to get this word out to a lot of people, to like restore the vote. But a lot of people are eligible for things and they don't know about it.
It's true.
And I also want to say, your Hennepin County clerks are the first people that people run into and they don't do a good job. And you need to train your clerks. Just in this.
When you say clerk,
To explain it's the court.
like court clerks?
Yeah, it's the judicial system. Yeah.
No, when you go in and get your driver's license or you try any of them, there are some that are really good, but they stand in the way of people's lives if they need to be trained.
I promise you, I wish I was in charge of the court system.
But the people are in charge of the court system.
It's not, it's the
So the
court
one-
system that, where you go for the driver's.
That's Hennepin.
Yeah, it's in the county.
Right.
No, well, those are the ones that
Absolutely.
need to be trained.
Yes, yeah.
I love that you're looking at me and like she has the power to fix that. I wish that I did. Unfortunately, I can mostly handle what happens in the Hennepin County Attorney's Office, but I have been working with District Court, like you said, the self-help desk and the law library to get this information out there so that when people come to them with questions, they can walk them through this website instead of the expungement petition itself. Sir?
Yes, you spoke earlier about the felony murder, basically, the new statute concerning felony murder.
Mm-hmm.
Now, make me understand, well, from what I'm hearing again, all of these are statutes that's been passed already, because if someone's convicted of felony murder, it was basically a violation under Prende and Blakely, because those sentencing factors weren't considered by a jury, they were given by the judge.
Okay.
So, and I know this concerning 60911, which was possession of a weapon, that never went to the jury, and all of the old cases, and they never returned it. So those are substantial violations and not, what's the word they always use? Well, anyway, those are violations that should be under the Constitution corrected. So what I'm trying to say is, what's the difference now again with this felony murder statute, where you're not making it retroactive, but y'all are bringing in the newcomers when it was already a violation of Blakely and every other of Blakely and Apprende.
So the felony murder law, the aiding and abetting felony murder law is very, very specific. And so we can, unfortunately, we're limited by the law and what we can do and how people who are petitioning the court can seek relief. So for aiding and abetting felony murder, it is retroactive. The legislature actually did make it retroactive. So that's what we are focusing on for those people with those convictions now.
Now again, we know that this brings back NAFLA. Y'all use that. I know y'all will. I won't say y'all per se, but y'all officers, the predecessors, always use NAFLA concerning real issues, and they never address them. So what do y'all plan on doing about this, during this situation now?
Sure. So that's something that Mary, wanted us to talk about.
Yeah, and it was just, not to get too much in the weeds, but in the Marvin Haynes case, I waived it. So I personally waived that So the issue, and for all of you who are here, this issue is going to come up in this next session, legislative session that's starting next
Yes.
month. And so you all need to be there advocating for the fact that it shouldn't be reliant on an individual county attorney to waive it. Because we could have said, you're barred by NAFLA, right? And so there needs to be a legislative change for the entire state. And I know you have a lot of questions, but I wanted Claire to talk just a little bit about the difference between PISA and conviction integrity.
Yeah, so something you'll hear a lot, especially with the exciting release of Mr. Haynes, is about conviction integrity. So what we're talking about there is when cases are being reviewed for possible wrongful convictions or innocence claims. Mary is really committed to the establishment of a conviction integrity unit in our own office. So the Minnesota State Attorney General has a conviction review unit that's doing that work. There are some Hennepin cases there, but we're going to be establishing a conviction integrity unit. We just got approved for 2 positions for that unit in January. So we are going to start finally being able to staff that up. So that's a place, again, that's where folks who feel like they have innocence claims or were wrongfully convicted, we're going to be able to take a look at some past cases internally. That is in contrast to when with PISA, we're trying to adjust an excessive sentence. Yeah, Marlene.
So we are working to pass legislation right now around that, Kanafia law. And so anyone here who wants to know more, you can, get in contact with me. My name is Marvina Haynes. I'm the founder of Minnesota Wrongfully Convicted Judicial Reform. And that law by itself has been keeping our people, in prison for years because their case have never been able to be looked at because they were barred, no matter of the evidence that you have. But this is my comment for you guys. When we're talking about this expungement, a lot of times what I see is that there's a lot of fines that comes with court. Is there anything that's going to be put in place where these old cases will have an opportunity to do like community service or things like that to pay off the fines to be able to even apply? Because if your fines aren't paid off, you can't even apply to get an expungement. And families live in a lot of poverty, and the fines per court are so high.
You're right about that, and unfortunately, it doesn't address any fines. You are right that fines, fees, and restitution, outstanding restitution payments, you can still apply, but it will be a reason why the judge denies your petition.
So is there anything where we
No,
can
ma'am.
like offer families community service or ways to be able to pay those fines back? I think that will help families out a lot because there's a lot of families who want to be able to apply, but if I don't got the money, how
Agreed.
can I?
Unfortunately, no, but that is an excellent idea, and Jamel over there's got somebody's ear. Let's propose that.
Yes, sir. Mauricio Moore from Jive. I'm kind of confused because I was under the impression that if you had a lifetime bar, there was nothing you can do to expunge your record. If you had a life, DHS could see it and BCA could see it. That's what's keeping us just impacted individuals out the healthcare field. Because as we go up, apply for these jobs, DHS, even when our record's expunged, DHS can see it. Also the BCA. So my problem with expungements in general, it's all this, I don't even know what this is, but you guys are telling people they can get their records expunged, but yet still, the reason why I'm expunging my record is for me to get back into the workforce, and it's not doing the job after all this money I spent. So that was a comment about it. The other thing is I just want to make one, because I got a bunch of buddies calling me from the joint. This application, if I print it off in February, I can't use it in any other county, just Hennepin.
Correct.
All right.
This is just Hennepin. Yeah, and it's not an online form. It's going to be like an application you can download.
So, I want to speak to your comment originally though. And actually, Jamel and I have been working with the legislature on this exact issue because it sucks and it shouldn't. You're totally right. So the problem is not that DHS can't seal your records. It's that DHS will not seal your records unless they are specifically given notice. And so if an individual were to petition in the normal course of business, they'd go to, say, the self-help desk, and the self-help desk would be like, here's a list of agencies that are involved in your offense. You need to send each one of these places a copy. They will never put DHS on that list because DHS is almost never involved in someone's offense. However, DHS will not seal records unless they are given notice. So that feels wrong and like we're hiding the ball. So Jamel and I have been working to fix that part of the statute so that people are aware that that's an extra step that they have to do, right? But DHS records can be sealed. You just specifically have to give them notice to do so.
There's one more thing. It's to me, because I'm just impacted. It just feels like I don't even understand what's going on. Is the punishment the crime? Is my conviction the crime? Is parole the crime? Or do you want me to just walk around for the rest of my life unable to get employment, housing, because it benefits everybody but me?
That's
I don't
why we're
understand
doing
why
this.
can't this just be a unilateral reform across the board that when you're done with your time, you're done with your time. Period.
So that is actually kind of what's happening. I know. I completely agree. Because that's what this initiative is about. And that's what Mary is really pushing, the direction Mary is pushing her office to move in, is that you commit a crime, we tell you what it's worth, you do that, and then we punish you for life. No. You've paid your dues, you did what we said this crime was worth, and you should be done. And so that's what all of this is. And believe it or not, the Clean Slate Act is hopefully when it comes into effect, will go a long way in the automatic nature of it, just taking it out of the person's hands so they don't have to take these extra steps will hopefully go a long way into alleviating that problem.
Sorry, and I wanted to speak to that because we are bound by the legislature in many ways. And I'm actually very proud, with Jamel's help this last session, we testified, we supported all kinds of legislation that passed, including prosecutor-initiated sentencing adjustment. And so what we try to do as an office, we have a lot of discretion. And within that discretion, we are trying to make it more possible for people to come out of the system without barriers, okay? But there are only so much we can do without legislative changes. So what I would say about expungement is, yeah, you're right. There are a lot of problems there, but within that framework that we've been given by the legislature, we're doing the best we can. We're trying to expand it as much as possible. And so this is a pitch for all of you to talk to your representatives, senators, representatives.
Please.
Yes. Jamel talks to them all the time, and they want to hear from you as to what your priorities are. Because the more community pushes for new tools and to lessen the barriers, the more the legislature will hear that, and then we will have those tools, and we will do the best we can within those tools.
I have a good question because you want us to talk to them about priorities of human. Most people should already know that. So priorities is you don't want your loved ones to be incarcerated and then have to spend the rest of their life trying to find a job, and then the only job they can get is at McDonald's, and then they barely can take care of their family. You don't want your loved ones to be taken away from their children. So we need the legislators, in which all of us probably work, all of us probably pay taxes to fund legislating. Why don't they come to common sense? And why can't they understand that?
So the question is, why do we have to tell them what they already should know?
Yes.
My answer to that is, unfortunately, they don't know it. And they are not going to come to community to ask, at least a lot of them. Some of them do. And so a lot of what legislation is, or what legislators respond to, is constituent people who are taxpayers or voters or that kind of thing, bugging them and telling them, this is what we want. Okay? They need to hear that. And I know, I appreciate what you're saying about what would they want for their loved ones. And I can tell you a lot of people just don't think their loved ones, I've had this experience a lot. There are a lot of people who don't think certain things would ever happen to their loved ones, and they don't really think about the process. And then when it happens to their loved one, they're the first one right there saying, this is unfair, okay? Have that experience all the time. So part of this, and we work really hard at this, is educating people. As all of you in this room know, the system is very mysterious. It is not transparent. It is I mean, poor Naughty trying to walk through this stuff, right? It is purposely non-transparent. It is purposely mysterious. And one of my goals as county attorney is to make it as understandable to all of you and everybody so that you can ask the tough questions. So that you can say to the people who represent you, why is this happening? Why aren't you doing this thing? And so it's hard work, and I know people don't have the time, I know it's harder, but those of you, I'm looking out here and I see you, Rob, over there, you've got the time to contact your legislators. So we have to join as community to demand what we want.
Maybe one more question.
One more question, Antonio?
No, I'm agreeing with you.
Your agreement.
We as community, if you feel that there's a problem, you gotta go to the legislation and bring it to them. They work for us. We don't work for them. We put them in power. So if you have a problem, you gotta go find out who's your representative, your senator, and bring those issues to them.
I'm gonna, and I wanna wrap it up here. I know people have questions and we'll be here afterwards too. But one thing I wanna say to you is this. People need to understand what you want and what your values are. And I would tell you one thing, and for those who haven't seen it, we have a wonderful first year video that Joanna right over there put together. And one of the things I experienced in my first year is a lot of really negativity about the things we are trying to do, right? If you just relied on the strip, for instance, you would think, yeah, I mean, I've never seen so many articles. Actually, it's about, I think, 65. Somebody counted 65 letters to the editor, articles criticizing our approach to youth. And when I go out into the community, which I do a lot, I go even to the grocery store, people come up to me all the time and they say, we support what you do. Thank you. But you know, and I appreciate that. But you know what? Those voices aren't being heard. You're all being drowned out by the loudest voices that some media give the platforms to, right? So you've got to make your voices heard. You've got to make your voices heard. Because so much of this is within the discretion of the county attorney, and that's dependent on who the county attorney is. And so if this is work that you think is important, you've got to support it.
Yeah.
So we're going to end there.
Wrap it up, but feel free to have folks come on up.
Yeah, so we're going to end there. Just
And really quick, let's really quick. I think Mr. Suki, you have a question, sir? Community elder?
Oh.
You have a quick question?
Sure.
Yes, sir.
My question was, when somebody writes a letter to your office, where does it go to?
Yeah. When somebody writes a letter to our office, where does it go? So we have something called Citizen Info, where people can email. They can.
No, I'm talking about from Stillwater.
Oh, from Stillwater.
Stillwater, if you go to written you, Mark Osler.
Yeah.
I think you go to St. Paul, St. Thomas, and if he's in Minneapolis, I believe you go to downtown, and he has not got any answer from you or him.
Yeah. So here's
where do the letters go? Who gets the letter?
The letters go to my assistant, and I get hundreds. Okay. I can't possibly respond to every letter I get.
Okay, I was wondering about that.
Yeah, I wish I had the capacity to do that, and I don't. And so they try to flag letters for me, and I try to divvy them up. I mean, somebody emailed Citizen Info today, I think, and it got passed along to me, and I said, Claire, I think this is your issue. We try to get them sent to the person who can directly answer it if we can, but the letters I get, there are stacks of them. And I wish we had more capacity. I wish I could respond to each individual one, but I just can't.
And so the applications, but some of the.
He wrote Mark Osler for something.
Sure. Yep.
And he sent me an email to send to Mark, which I have to send me.
And let's touch base with Jen. She does community outreach. Jen right there, behind in the black.
Follow up.
Yeah, if she can follow up with you, and we can see if we can get some of those responded to. If that's fine. And with that, I think we'll find a wrap.
Okay, and we'll stay around here, and there's also still food,
Yeah,
so
please get some
come
food.
on up and get some food, and thank you so much.
Thank you so much.
Thank you, everyone.